Good evening, Shubham. Okay, so we have five people now. I was waiting for others to join. How are you everyone doing, guys? I can just see one comment. Shubham has commented on the chat box. Hi Pritika, how are you? How is the preparation going, guys? Come on, start commenting on the chat box. I cannot see any of the comments. More people joining. We have five people. Okay, shall we begin with the quiz? Please comment a yes or a no, and then we'll begin with the hello anonymous. Let's let's start with the quiz then. Yes. Okay. So the very first question is Section 32 of the Limitation Act is repealed by repealing and amending Act of 1974, repealing and amending Act of 1908, repealing and amending Act of 1973, none of the above. Okay, Divya, get yourself comfortable, and we are at the first question only. Take your time and answer this question. I'm waiting for all of you to join and start commenting. Good evening, Medha. Welcome back. I hope the network connection is okay today. Okay, Pratika is saying one. Medha is saying two. Anonymous is also saying one. Section 32 of the Limitation Act. We started from the back today. I'm waiting for the other three people to answer. Take your time and answer the question, and then I'll move ahead. Come on. Okay, let's see the answer. The answer is option number one and not option number two. It is the Repealing and Amending Act of 1974 has amended section number 32. The few amendments are there in first schedule also. Yes, correct, Divya. And section 2 also. So everyone was right. Section 31 of the Limitation Act applies upon suit, application, appeal, or all of the above. Section 31. Can someone tell me what is section 31 of the Limitation Act? Okay. Pratika is saying 4. Medha is saying 4. Divya is also saying 4. Shubham is also saying 4. Let's see. Yes, it is 4. It applies to all the three petitions, which are suits, appeals, and applications. And section 31 is basically, you call it a section of like to bar the barred suits. And yes, hi Kumujja, to barred suits and pending suits. This is the provisions relating to barred suits and the pending suits, which apply to all the suits, applications, and appeals. Okay. Next question is, under Section 25 of the Limitation Act 1963, the easement rights over the property belonging to the government are acquired by continuous and uninterrupted user for 12 years, for 20 years, for 30 years, for 60 years. Everyone is saying 3. Yes, it is 3, and it is under clause 3 of section 25 belonging to the government, I asked. So it is 3 and not 20 belonging to the government, I asked. So it is 3 and not 20. Guys, yes. Shaktija said B. No, Shaktija, please read the question again. Not to the government, but to the not to the private person, but belonging to the government, it is 30 years. Okay, the right to access and use of light or air shall be absolute and indefeasible, where the access and use of light or air to and for any building have been peaceably enjoyed therewith as an easement and as of right without interruption of 1 year, 3 years, 5 years, 20 years. Now answer this question. Okay, everyone is saying 4. Yes, it is 4, directly taken from section 25, clause 1. And the property belonging to government, the time period will be 30 years and not 20 years. So mark it on your Bear Acts also under section 25. It is a very important section, law of prescription. So it becomes really important under the Limitation Act, both for the point of view of prelims and mains. A suit against the obstruction in the enjoyment of easementary right acquired under Section 25 must be filed within 2 years of such obstruction, within 1 year of such obstruction, within 3 years of such obstruction, within 12 years of such obstruction. Okay, difference of opinion here. It is option number one, anonymous, and Divya. Welcome, Mahima. Divya answered it correctly. Medha, Kanika, all of you answered it correctly within 2 years of such obstruction. This is mentioned in the clause number, I think, 2 of section 25 only, where it is mentioned that you have to file a suit within 2 years. Like the meaning of the clause is such. Yes, Mahima, it is option number one. Which section of the Limitation Act provides provision regarding acquisition of easement by prescription? I answered it before only. 21, 23, 25. None of the above. Yes, it is option number 20. It is option number C, which is section 25. Yes. By prescription is section 25. For claiming easementary right, one must have enjoyed open and peaceful access for a period of 15 years, 10 years, 20 years, or 40 years. Come on, the language is changed, but the question is same. Kanika is saying 3. Pritika is saying 3. Yes, it is 3. The same thing asked in a different manner. Where any land or water upon, over, or from which any easement has been enjoyed or derived has been held under or by virtue of any interest for life or in terms of years dash from the granting thereof, the time of the enjoyment of such easement during the continuance of such interest or term shall be excluded in the computation of the period of 20 years in case the claim is within 3 years next after the determination of such interest or term resisted by the person entitled on such determination to the said land or water, exceeding 3 years, exceeding 12 years, exceeding 20 years, or exceeding or none of the above. Everyone is saying 3. Yes, it is 3. It is the language of section 26 is mentioned. It excludes certain years, and the years are 3 years, and this is mentioned under section 26. Yes. Which section of the Limitation Act deals with exclusion in favor of reversioner or servient tenant? 24, 25, 26, 27. Yes, it is section 26. It was a direct question. The general rule is that the law of limitation only bars the remedy but does not extinguish the right itself. The exception to this rule is contained in 31 of the Limitation Act, section 27, section 26, or 25. Divya is saying B. Anonymous is saying 2. Yes, it is 2. Section 27 is the exception to this rule that the law of the limitation only bars the remedy, but it does not extinguish the right. But Section 27 ends the right to the property and not only the remedy. Yes, everyone is right. Section 27 does not apply to the suit for possession laid in the specified civil court under the Act, the appeal for possession laid in the specified civil court under the Act, the application for possession laid in the specified civil court under the Act, none of the above. Everyone is saying option number B. It is option number one, guys. The only it applies only to the suit specified and not to the appeal. Okay, does not apply to. Yes, it does not apply to option number B. Yes, correct. It does not apply to appeals, but it applies to only the suits. Correct. Section 27 does not apply to appeal. If the question would have been Section 27 applies to, then the correct answer would have been only option number one. Okay, Section 27 of the Limitation Act applies to suits, appeals, execution application, all of the above. A direct question again. Yes, the answer is correct answer is option number one. As I told you that Section 27 of the Limitation Act only applies to suit. Which section of the Limitation Act deals with the suit on a bill of exchange or promissory note payable at a fixed time should be filed within 3 years from the date of the execution, the date on which time expires, the date of demand, the date of denial to pay? A question from the schedule now. You need to learn the schedule. Okay, everyone is saying option number one. Shubham is saying option number three. And the correct answer is none of the above. The correct answer is two. Suit on a bill of exchange or promissory note payable at a fixed time should be filed within 3 years from the date on which the time expires. Yes, correct, Divya. On which the time expires. Correct. Which of the following section of the Limitation Act gives recognition to the concept of adverse possession? 22, 24, 26, or 27? Adverse possession. Everyone is saying option number D. The correct answer is option number D. Yes, it is 27. The law of adverse possession is based upon the principle that a land cannot be left in abeyance for a long time, as already stated above. Hence, someone has to be the owner of the land when the rightful owner has lost the rights once failed to take action as provided under Section 27. So, in the said situation, the person in adverse possession of the land becomes the rightful and absolute owner of the land as per Article 65 of the Schedule 1 of the Limitation Act. So, remember the article number 65 has to be related with section number 27 of the Limitation Act, which also signifies the concept of adverse possession. Yes. Which section of the Limitation Act provides that on lapse of time, not only the remedy is barred, but the right of the property is also extinguished? This is already done. But for the new people, please answer the question. Yes, it is option number one. Yes, correct. The limitation is the statute of repose. It ordinarily bars a remedy but does not extinguish a right. The only exception to the said rule is to be found in Section 27 of the Limitation Act 1963, which provides that the determination of the period prescribed thereby, limited to any person for instituting a suit for possession of any property, his right to such properties shall also be extinguished. This was held in which case? Prem Singh and others versus Birbal and others, AIR 2006, Supreme Court. Patel, Naran Bhai, Margha Bhai and others, deceased Dhula Bhai, Galba Bhai and others, AIR 1992. Muhammad Ashfaq versus State Transport Appellate Tribunal, UP and others. Chheda Lal versus Officer Commanding Station Meerut Cantonment, AIR 1941, Allahabad 201J. Pritika is saying one but not sure. Shubham is saying pass. Yes, it's better you pass the question in the exam actually if you are not aware about all the options. Divya is guessing as B. The correct answer is option number one. Pritika, you were right. It is Singh and others versus Birbal. Please take out your Bear Acts and mention this case law because this is The case law is actually telling the whole Bear Act language only. So mention this case law in front of section 27 on your Bear Acts only, so that it remains with you till the time you are preparing for the exam or till the time you become a judge. It will be with you if you mention this on your Bear Acts. Yes. Okay. When a person is obliged to institute a suit for possession of any property, then by operation of Section 27 of the Limitation Act, at the determination of the period thereby limited, his right to such property shall be extinguished. Section 3 of the Limitation Act bars institution of the suit after the prescribed period, and the suit shall be dismissed through limitation as not been set up as a defense. Patel, Naran Bhai, Marga Bhai, and others versus deceased Dhula Bhar, Galbha Bhai, and others. Prem Singh and others versus Birbal, Mohammad Ashfaq versus State Transport Appellate Tribunal, Chedalal versus Officer Commanding Station Meerut Cantonment, or Krishnamurthy S. Sitler versus O.V. Narsimha Sethi. Another case law based question. Mention this in the space of section 3 only if you do not know the answer. Prem Singh and others to hat gaya na. You are left with the other four options. Nobody? Yes, it is option number one. It is Patel, Naran Bhai, Margan Bhai, and others. Please mention this case law in front of section 3 only of the Limitation Act. The plaintiff must plead and prove the date on and from which he claims to be in exclusive, continuous, and undisturbed possession, and also that such possession was actual and to the knowledge of the real owner. He has also to show hostile title and communicate it to the real owner. This was held in which of the following cases? Prem Singh and others versus Birbal and others, Mohammad Ashwaq versus State Transport Appellate Tribunal, Chedalal versus Officer Commanding Station Meerut Cantonment, Krishnamurthy S. Sittler versus O.V. Narsimha Shetty. सारे जो ऑप्शंस के केस लॉज हैं उसका हेल्ड आई एम टेलिंग यू वन बाय वन. Shubham is saying fourish. Okay. Yes, the correct answer is option number D. Pritika, not always option number one is the correct answer. It is Prem Singh and others versus Birbal. Please mention this case law also. Section 28 of the Limitation Act was repealed by Repealing and Amending Act 1974, Repealing and Amending Act of 1973, Repealing and Amending Act of 1972, or Repealing and Amending Act of 1971. Yes, anonymous, it was right. It was option number D. Okay. Anonymous is saying one, Divya is saying one, Shubham is also saying one, Pritika is also saying one, and the correct answer is one. It is by the Amending Act of 1974. Yes, the 1974 year has been a major amendment for Limitation Act. Which provision of the Act stipulates for the purpose of determining any period of limitation prescribed for any suit, appeal, or application by any special or local law? The provisions contained in Section 4 to 24 shall apply only insofar as and to the extent of which they are not expressly excluded by such special or local law. 23, 25, 29, or 30. Come on. Okay, everyone has started answering and they are answering option number C. And yes, it is the direct language taken from section 29 itself. 29 ka clause 2 was the correct provision here. Yes, everyone is right. It is option number 2. Section 29 clause 1 of the Limitation Act saves which of the following sections of the Indian Contract Act? Section 22, section 29, section 26, or section 25? Kritika is saying 3. Shubham is saying D. Pritika is saying again D. Okay, that was for previous answer. I think Divya is saying D. Meda is saying D. Yes, it is D. It is section number 25, which is saved by section 29. Section 25 is what? Agreement without consideration is what? Voidable, void, or valid under the Indian Contract Act. Section 25. Which is the correct of the law about the law of the limitation? Limitation bars the judicial remedy. Limitation extinguishes the right. Limitation bars the extrajudicial remedy. Limitation is a substantive law. Yes, it is void. Which is correct? Yes, it is void. Come on. Yes, it is option number one. Limitation bars the judicial remedy and not the right. Section 27 is the exception here. Again, the case law based question. Lordships observed as under Section 29, Clause 2 of the Limitation Act 1963 make Section 5 applicable in the case of an application for renewal unless its applicability can be said to be expressly excluded by any provisions of the Act. Statements made under which case? Patel Naran Bhai, Marga Bhai and others versus deceased Dhula Bhai, Galbha Bhai and others, AIR 1992, Prem Singh and others versus Birbal, Mohammad Ashwaq versus State Transport Appellate Tribunal, Cheralal versus Officer Commanding Station, Meerut Cantonment. Come on, guess it. I know most of you will pass the question. Okay, Divya is saying option number three. Yes, it is option number three because option number one and two were already done. So you mentioned this case law in front of section 29 only. Yes, yes. The expression the remaining provisions of the act shall not apply in the amended section 29 of the Limitation Act simply means that they will not to apply they will not to apply propri viogre, that is merely by virtue of the Limitation Act itself, and that if they were to apply, the grounds for applying them must be found in the special or local act. They were to apply, it is a non-Indian term, and like it is a maxim, which means that is merely by virtue of the Limitation Act itself, and that if they were to apply, the grounds for applying them must be found in the special or the local act. uh, they were to apply, that is merely by virtue of the Limitation Act itself, and that if they were not to apply, the grounds for applying them must be found in the special or the local act. Shubham is saying okay. Divya is saying C. They were to apply as if it is directly by the Limitation Act itself, and that if they were not to apply, the grounds for applying them must be found in the special or local act. Shubham is saying 1, and the correct answer is 1 and not C. They were to apply directly by the Limitation Act itself, merely by the virtue of the Limitation Act itself, and that if they were to apply, the grounds for applying them must be found in the special or local act, because it saves the Limitation Act, right? Section 29 saves the Limitation Act, and it makes the special or the local act applicable. So they are not to be applied by the Limitation Act, but if they had to apply, they were the only special or local acts will come into picture. Yes, option number 1 is the correct answer. According to Section 29, Clause 3, nothing in this section shall apply to any suit or other proceeding with respect to marriage, divorce, either of the above, none of the above. Yes, it is option number 3 and directly taken from the Bear Act. To both marriage and divorce, none of the proceedings will be applicable. Yes, correct. Which of the following will not apply to cases arising in the territories to which the Indian Easements Act 1882 may for the time being be extended? Section 25, 26, definition of easement in section 2, all of the above. Everyone is saying option number 3. Is it for this answer only? Pritika is also saying option number 3. It is option number 4, guys. And all of the above will not be applicable if Indian Easement Act will apply. And this is okay. Shaktija is saying option number 1. This is mentioned under section 23, mentioned under section 30 directly. Yes. And it is mentioned under section 29 ka clause 4 also. Shall not apply to cases where Indian Easement Act will be applicable. No, the answer is all of the above. Section 25 and 26 भी जहाँ पे apply होता है, like this is basic, जहाँ Indian Easement Act extend होता है, section 25 and 26 will not come into the picture. Provisions for suits for which the prescribed period is shorter than the prescribed period by the Indian Limitation Act is contained in section 28, section 29, 30 or 31. Yes, it is option number 3, 30. Section 30. Very good, Pritika. Yes, yes, it is option number 3. Correct, Divya. Correct, Medha. Correct, Shubham. As per section 30, any suit for which the period of limitation is shorter than the period of limitation prescribed in the Act, it may be instituted within a period of 7 years, 20 years, 90 days, or 6 months. Yes, it is option number 1, 7 years, and directly taken from the Beer Act. Section 30 clause A talks about the suits, while 30 clause B talks about the appeal or application. As per section 30, any suit for which period of limitation is shorter than the period of limitation, it may be instituted within a period of 8 years, 21 years, 91 days, 7 months. This is the appeal or application. This is not suit, but for any appeal or application for which the period of limitation is shorter than the period of limitation prescribed in the Act, it may be instituted within a period of, yes, 91 days, which is 3 months. Appeal and application ke case mein it is 91 days. Yes. Section 12 of the Indian Limitation Act talks about disability of one of several persons, continuous running of time, exclusion of time in legal proceedings, exclusion of time in cases where leave to sue or appeal as a pauper is applied for. Section 12. Yes, Pritika is right. It is exclusion of time in the legal proceedings. Each clause of Section 12 stands important for the point of view of examination for both prelims and mains. Yes, correct. Section 12, Clause 1 of the Limitation Act is applicable on only suits, appeal, application, or all of the above. Come on, guys. Yes, it is all of the above. It applies to all the three things: suits, appeal, and application under Section 12, Clause 1. According to Section 12, Clause 1, which of the following day will be excluded? from which the period of the limitation to any suit, appeal, or application is to be reckoned. Suit is dismissed, application is accepted, and or none of the above. Yes, but the appeal or application has to be filed on the 91st day. First days, see, we are at the correct clause here also. So always, whenever there are days mentioned, it is 1 month. Like we calculate 14 plus 1 in section 167 also, right? For the remand thing. So it is 94, 91 days. In the case, it is not mentioned 90. If 90 and 91 both are mentioned, then you will mark 91. Okay? The first day is always excluded. So that is the reason why 91 is the correct answer here. It will never be mentioned 1 month plus 1 day. Month में है तो month में ही लिखा होगा. Yes, it is option number one. In computing the period of limitation of for any suits, appeals, or application, uh, the day from which the such period is to be reckoned shall be excluded. Always. When will it be permissible to exclude the time period spent on the pendency of an earlier suit for computing the period of limitation for filing a subsequent suit? If the earlier suit is filed in a court lacking pecuniary jurisdiction, if the earlier suit is filed in a court lacking territorial jurisdiction, if the earlier suit is filed in a court which lacks subject matter jurisdiction of the above, or all of these. See, whenever we count the days, we always count plus one. So the most appropriate option will be 91 and not 90. Rest it depends upon the state who is checking if they give such confusing options 91 and 90. Otherwise, the correct answer will be 90 only because Bayer Act mentions it. अगर 91 mention नहीं है और 90 mention है तो go with 90. Yes. Okay. No two, but section 12. First, the exclusion, section 12. Yes. The correct answer is option number 4. All the four clauses, all the three clauses are mentioned here under section 12, and all the things are excluded. Why B? Why everyone is saying B? Why everyone is saying B? Can someone comment on the chat box? All the three jurisdictions are excluded. No, all the three jurisdictions are excluded, guys. Okay, till the time you explain the answer, I will move ahead with the question. Section 13 of the Limitation Act applies to suit filed in forma pauperis, appeal filed in forma pauperis, both 1 and 2, none of the above. Yes, it is both 1 and 2. Both in the case of suits or in the case of appeal, whenever a person who is a pauper, the section 13 will come into the picture and apply to both suits and appeals. Yes. Section 5 and 14 of the Act, though independent, are not mutually exclusive. Even in a case where Section 14 applies, Section 5 is not excluded. This was mentioned in which of the following cases? Samuel Joseph versus Ramchandran Chalyan, Vaditho Anantharao Nayak versus Bhumi Shetty Rajaya, Anil Pratap Singh Chauhan versus Onida Sevak Limited, Vijay Kumar Rampal versus Diwan Devi. Mention the correct case law here in front of section 5 and relate it with section 14 and why is it related. Okay, Pritika is saying two. The answer is option number one. It is Samuel Joseph versus Ramchandran Chalyan. Please may mark it on your Bear Act. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceedings, whether in a court of first instance or of appeal or revision, against the defendant shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which, from the defect of jurisdiction, is unable to entertain it. Exclusion of such period has been laid down under which section of the Limitation Act? 13, 12, 15, 14. Yes, it is section 14 ka clause 1. Everyone is right. A bank has loaned money to B on 2nd January 2015. The limitation available to the bank for suing recovery of said monies from B expires on 1st January 2018, 2nd January 2018, 3rd January 2018 or 2nd January 2016. अब आंसर करो शुभम. The first day rule. Pritika is saying option number 3. Divya is saying option number 3. Shubham is also saying option number B. C. Okay, the limitation available expires on the bank for suing the recovery of the said monies from B expires on 1st January 2018. I think this is 1st January only because, see, I read the question and I marked it as doubted, but I kept it in the quiz because I needed to discuss also. See, 1st January is a public holiday, right? Correct. 1st January is a New Year's is a public holiday. Is it? So shouldn't it be 1st January 2018? Yes, by applying that rule, 3rd January should be the correct answer, but the state marked no. Divya is saying no. 1st January is not a public holiday. Courts are closed on 1st January. Yes, then also the correct answer should be 2nd January 2018. But if we apply the first day exclusion rule, the 2nd January, say 2nd January is excluded, and then we count it from 3rd January, then the correct answer should be 3rd January 2018. Is that so? Public holiday hai, ma'am. हाँ. Public holiday hai, when the court reopens, that means 2nd January 2018. And if we excludes 2nd January 2015, then the correct answer should be 3rd January 2018, but not 1st January. So the correct answer should be C here, but the state marked it. I think this was Haryana's question, and the state marked it option number 1. I don't know what happened after the objection, but the official answer key marked it option number 1. According to me, also, it should be 3rd January, even if 1st January is a public holiday. ठीक है. Let's move ahead. In a suit, I think it is 3rd January only. In a suit filed by a plaintiff, the defendant in his written statement has taken the objection of non-impediment of necessary party. Despite such objection, the plaintiff continued the suit and the suit was finally decreed. At the first appellate stage, the plaintiff withdraws the suit and with liberty to file a fresh one on the same cause of action and subsequently filed a fresh one. The period spent by the plaintiff in the earlier suit under Section 14 of the Limitation Act is liable to be excluded with on the ground that the plaintiff was prosecuting the earlier suit with due diligence and in good faith. Not liable to be excluded as the plaintiff cannot be said to be prosecuting the earlier suit with due diligence and in good faith. Liable to be excluded under Section 14 Clause 3 of the Limitation Act. To be excluded or not to be excluded is the discretion of the court. Okay, Pritika is saying 3. Please answer everyone. यहाँ पे तो कोई negative marking नहीं है, so you can at least try answering the question. Only Pritika is answering. Shubham has also answered. The correct answer is option number 1. It is a due diligence thing, and the plaintiff will be considered as yes, it applies under Section 14 clause, like fresh suit के लिए जो भी exclusion है, that will be given under Section 14 clause 3, but it comes under due diligence and in good faith. सो उसको वहीं से एक्सक्लूजन मिल जाएगा, उसको 14 क्लॉज 3 में आने की जरूरत नहीं है. यस, इट इज ऑप्शन नंबर 1. करेक्ट शुभम, करेक्ट दिव्या, करेक्ट मेधा. Section 5 of the Limitation Act applies to suits and execution applications, suits only, execution applications only, appeals. Section 5 of the Limitation Act applies to what? Okay. It is option number 4. Yes, it is option number 4. It applies to appeals, and if the question would have been Section 5 of the Limitation Act does not apply to, then what should be the answer? Section 5 does not apply to. If I make it a negative question, then what should be the answer? Yes, then the answer should be suits and execution proceedings. Section 5 of the 15 of the Limitation Act excludes the computation of limitation, period of notice, time required for obtaining consent, time required for obtaining sanction, all of the above. Section 15. Yes, it is option number 4. All the clauses are mentioned, and it was a direct question. Uh, This is also a repeated question. Time taken in proceedings to set aside the sale in suit for possession by a purchaser in execution is liable to be excluded under Section 15 Clause 4, 15 Clause 2, 15 Clause 3, or 15 Clause 1. Purchaser in execution in a suit for possession by a purchaser in execution. Yes, it is option number 1, and it is excluded under Section 15 Clause 4. Correct. Everyone is correct. In which section of the Limitation Act effect of death before accrual of right to sue is provided? Section 16, Section 18, Section 19, or Section 20? Yes, it is option number 1, which is Section 16. Effect of death on or before the death or on or before the accrual of the right to sue, seizes the right to sue, extends the right to sue, enables the court to dismiss the suit, none of the above. Yes, it extends the right to sue and not seizes the right to sue, or not the it does not enable the court even to dismiss the suit. This was correct by everyone. Pritika, Shubham, Medha, Divya, everyone is correct. Okay. Where in case the suit or application is based upon fraud or mistake, the period of limitation shall not begin to run until the plaintiff or the applicant has discovered the fraud or the mistake. The statement is discovered the fraud or mistake. The statement is false, true, provided under section 17, not provided under Limitation Act. Choose the correct combination. None of the option is correct. Option only one is correct. 1 and 4, 2 and 3. Yes, by Allah's legal representatives. Correct, Kritika. Yes, it is option number 4. Both the option 2 and 3, like the statement is also true and it is mentioned under section 17. Section 17 of the Limitation Act takes within its ambit concealment, frauds, mistake, all of the above. Yes, it is option number 4. All of the three things are mentioned under section 17. By either fraud or mistake or by a concealed document, section 17 will apply. Yes. Acknowledgement after the period of limitation is of no effect, gives rise to an independent and enforceable contract, neither one nor two, both 1 and 2. Pratika is saying 1. Acknowledgement after a period of limitation. Yes, it is option number 1. In case of the acknowledgement of debt under section 18, if such acknowledgement is before expiration of the prescribed period of limitation, a fresh period of limitation shall be computed. And after the period of limitation, if the acknowledgement is done, it is of no effect. No, it is option number 1. Pritika and Shubham were right. Yes. On acknowledgement, a fresh period of limitation starts from the date of signing of acknowledgement, from the date of promise of acknowledgement, from the date of expiry of extended period of acknowledgement. Come on, a direct Bare Act based question it is. Yes, it is option number 1 from the Divya is right, Pritika is right, from the date of signing of acknowledgement. Correct. Acknowledgement made by a person other than a person under liability is good as if the person making it is known to the person under liability, the person making it is an agent to the person under liability, the person making it is a servant of the person under liability, none of the above. Everyone is saying option number B. Yes, it is under section 18 and as if the person is agent and not the servant, or not if the person is known. It is the agent. Yes. Correct. As per section 19, if any payment is made on account of a debt before the expiration of the prescribed period by the person liable to pay the debt or by his agent duly authorized in the behalf, a fresh period of limitation starts running from the time when the suit was filed, B, when payment was made, C, when the creditor demands, or D, none of the above? Divya is saying option number B. Meda is saying option number B, and it is option number B. Yes, correct. Before expiry of limitation period of limitation, A has acknowledged in writing the amount due as debt from B and has promised to pay. What is the effect of such acknowledgement? No effect on the period of limitation. Fresh period of limitations will start from the date of such an acknowledgement. Period of limitation will be extended for 6 months. Period of limitation will not be applicable. Come on, very easy. Yes, it is B. And fresh period of limitation always starts when the acknowledgement is signed, and when the like on the day when the acknowledgement is signed, the fresh period of limitation will be applicable. Where a document can be construed as an acknowledgement of loan, which of the following sections come into play? Section 15, Section 16, Section 17, or Section 19? Yes, it is section 19, and it was a case Narsinga Sahu versus Banka Bihari Sanskriti College, which talked about loan, because the word loan is not mentioned in section 19, but the word which was used is debt or the interest on legacy. So you can mention this case in front of section 19. Okay. Narsingha Sahu versus Banka Bihari Sanskriti College. Okay. The expression agent duly authorized in this behalf in sections 18 and 19 shall, in case of a person under disability, include his lawful guardian, committee or manager, agent duly authorized by such guardian, committee or manager, all of the above. Yes, Pritika is saying option number 4, and it is option number 4. It is mentioned under section 20, clause 1, that what do you mean by agent duly authorized by law? Okay. Are we on the same page, guys? How are the questions? Are you guys feeling heavy? We have covered almost more than 50 questions, and we are already halfway through. Yes, Pritika is saying yes. No, it is not heavy. It's fine. Okay, let's move ahead then. Which of the following sections deals with the concept of acknowledgement under the Limitation Act 18, 19, or 20? All of the above. It is superb. Thank you, Pritika. Please answer the question displayed on your screen. Which of the following sections deal with the concept of acknowledgement? Is it only one or all the three? 18, 19, or 20? Come on, guys. It is all the four questions. Abhi bola tha. Effect of acknowledgement on loan, effect of acknowledgement or payment to others. Yes, it is option number D. Divya, correct. Please read the topic of acknowledgement again, and please read the index again of Indian Limitation Act. All of you who have answered option number 1. Yes, okay. When a new defendant is added in the suit shall be deemed to have been instituted against him from the date of his addition, from the date of institution of the suit, from the date on which issues are framed, or from the date on which summons is served on him. It is option number 1, and it is mentioned under section 21, clause 1. Then the date of his addition will be the date of the time when the suit shall be deemed to be instituted? Yes, it is option number one and not two. Only one person was able to answer it, uh, and that is anonymous. So please read section 21 again. पीछे पीछे के sections में you guys have problem थोड़ी सी, so please read that section again. Section 23 of the Limitation Act deals with continuing breaches and torts, suits for compensation for acts not actionable without special damage, computation of time mentioned in instruments, none of the above. Yes, it is suits for compensation for acts not actionable without special damage and not continuing breaches and torts. Continuing breaches and torts is mentioned under section 22. Yes, okay. Every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed if limitation has been set up as a defense. If limitation is pleaded at any time, although limitation has not been set up as a defense, all of the above, none of the above. Come on. All of the above? Yes, it is all of the above, and it is mentioned under Section 3 of the Limitation Act that in both the cases, even if the limitation has been set up as a defense, and if limitation is pleaded at any time, although the limitation has not been set up as a defense, after the limitation period, the suit shall be dismissed. Okay? Yes. An application preferred by a person requesting the court to intimate contempt proceedings against someone who has violated deliberately court's order can't be said to be an application referred to in section 3. Read with section 2b. This was held in Banabani Shankar Agrawal versus State of West Bengal, Lanka Venkateshwaralu versus State of Andhra Pradesh, Craft Center versus Concherry Coir Factories, Nasiruddin versus Sitaram Agrawal, Islamuddin versus Umesh Chandra Tiwari. Pritika is saying pass. Please mention this case in front of section 3 and 2b. This is the relevant case of section 2b also. It is option number 5, which is Islamuddin versus Umesh Chandra Tiwari. Okay. Where any special local law prescribes for assertion is prescribes for any suit, appeal, or application a period for limitation different from period prescribed by the schedule. The provisions of section 3 shall apply as if such period were the prescribed period by the schedule. Where a special and the reason is where a special law prescribes a period for limitation for filing appeal, but where there is no provision under the Limitation Act, the period of Limitation Act provided under the special law must be treated to be different from that under the Limitation Act. Both A and R are true, and R is the correct explanation of A. Both A and R are true, but R is not the correct explanation of A. A is true, but R is false. A is false, but R is true. Can't say. Assertion and reason. Come on. Nobody? We have 9 people and nobody is able to answer this. Okay, Divya answered it. Yes, it is option number 1. Both the statements are right, and A is the correct explanation of R. When any special law is different from the periods prescribed by the schedule, section 3 of the Limitation Act will apply as if the period prescribed by the schedule, and the explanation is also right, the reason is also right. Okay. It is option number A. Only Divya was able to answer it. Section 3 of the Limitation Act shall apply to only suits, appeal, or application, or all of these. Section 3 of the Limitation Act will apply to what? Yes, it is option number 4. It applies to all the three things. If any period of limitation is to be excluded from the prescribed period of limitation, the party necessary has to satisfy enough appropriate provision in section dash to dash of the Limitation Act 1963, 4 to 24, 25 to 27, 28 to 32, 29 to 33, or 30 to 34. Everyone, come on. Yes, it is section 4 to 24 and very well mentioned also. So it is section 4 to 24 and it is mentioned under section 3 of the Limitation Act that the party has to satisfy the appropriate provisions of the section 4 to 24 is excluded. Okay? The one in dark for the previous question, the one in dark. Okay. Okay. Section 4 of the Limitation Act includes suits, appeals, applications, all of the above, none of the above. Hi, welcome Lakshita. Was it? Was option number 1 bold? No. Okay. I cannot figure it out. Section 4 of the Limitation Act includes suits, appeals, applications, all of the above, none of the above. Okay, I am not able to see it. Yes, the correct answer is option number 4. It applies to all of the above. Plain filed the next day after period of limitation will be not barred by time if the plaintiff was outside India on the last date of limitation, if the plaintiff was unwell and suffering from viral fever on the last date of limitation, if the court was closed off for half an hour on the last date of limitation, if the advocate or the plaintiff forgot to file the plaint on the last date of the limitation, either one or two. Plaint filed the next day will not be barred by time. Okay, everyone is saying option number C. Yes, it is option number C. None of the excuses were applicable, but the only excuse which can extend the time is that if the court was closed even for half an hour on the last date of limitation, the plaint will not be barred by the time. Which section is based on the principle of lex non cogit ad impossibilia? Come on, section 7, section 5, section 14, section 15, section 4. Okay, everyone is saying option number. Okay, one is saying option number 5. Lakshita is Hi Nikunj. Divya is saying option number 5. It is section 4. Yes, it is section 4 and it is option number 5. Law will not ask you to do anything impossible. So, expiry of the prescribed period when the court is closed. When the court will be closed, the period of the time will be extended. Yes, it is option number 5 and not option number 4, Divya. Okay. Section 5 of the Limitation Act applies to suits, appeal and application, execution application, all of the above, none of the above. Nobody will answer. Only the new people will answer. That means Lakshata and Nikunj will be able to answer this question only. Section 5 of the Limitation Act applies to. Yes, it is option number 2. It applies to appeals and application. It does not apply to suits and execution proceedings. Condonation of delay under Section 5 of the Limitation Act can be claimed as a matter of right, is a matter of discretion on the court. Sufficient cause for the delay has to be shown, both 2 and 3, none of the above. Everyone is saying option number 3. Only Divya, Kunj, and Pritika answered option number 4, which is both 2 and 3. It is a matter of the discretion on the court. Obviously, condonation of delay, granting the limitation of time under Section 5 is a matter of discretion, and sufficient cause has to be shown. Sufficient cause के लिए बहुत सारे interpretations भी under the Indian Limitation Act. What is the period of limitation for a suit by or on the behalf of Government of India or a state government? 60 years, 12 years, 20 years, 6 years, 30 years. Everyone is saying 5. Yes, it is option number 5. It is 60 to 30, 60 years to 30 years in the case of a suit by a mortgager for the redemption of recovery of possession of the immovable property, or in case of mortgages for the foreclosure suits, or on the behalf of central government or the state government. It is 30 years, right? Assertion is Section 5 of the Limitation Act 1963 empowers the court to admit a suit after the prescribed period if the plaintiff satisfied the court that he had sufficient cause for not instituting the suit. Reason is even an appeal may be admitted after the prescribed period if the appellant shows sufficient cause for not preferring the appeal within the prescribed period. Both A and R are true and R is the correct explanation of A. Both A and R are true but R is not the correct explanation of A. A is true but R is false. A is false but R is true. Can't say. Shom is saying 4. Immediately he replied 4. Pritika is saying 1. Her assertion or reason का answer 1 नहीं होता है. It is 3. A is true but R is false. Why 4? A is true. Come on. Nikunj, why 4? A तो सही है. For R false है. सही से देखो. There are 5 options. There are 5 options, guys. Can't say option. Nobody is answering option number 3. A is true. अच्छा, सूट से कंफ्यूज हो गए हो क्या? ओके, यू आर confused by the word suit. Okay, it should not be suit, but empowers the court to admit an application or the appeal after the prescribed period, and even an appeal may be made after the prescribed period if the appellant shows sufficient cause for not preferring the appeal within the prescribed period. Yes, yes, yes. Okay, so that is why you guys are answering A is false but R is true. Okay, suits wale word se you are confused. Okay. Then in that case, R is obviously right, but A is true and R is false. Okay, so the correct answer should be option number 4 here and not 3, right? Yes. No, not only to appeals. Yes, R is correct. Yes, cause वो नीचे वाले को I was reading it as suit. Yes, cause Section 5 is applicable only to appeals. Not only to appeals, but it is only also applicable to applications. I was reading it as applications and not appeal. Yes, okay. So the correct answer is not 3, but answer 4 here. Suits, Section 5 is not applicable on a suit. No, Section 5 is not applicable on suits. So this word is derogatory. So A is literally wrong. If you go with the literal interpretation, assertion will be wrong. Yes. Then option 4 is right. Yes. Section 6 of the Limitation Act 1963 is available to only plaintiffs, defendants, respondents, all of the above, none of the above. Section 6. Yes, it was tricky. Section 6 of the Limitation Act is available to only plaintiffs. Yes, it is correct. Everyone is correct. Pritika is correct. Nikunj is correct. What is legal disability under the Limitation Act? Permanent physical disability, partial but serious physical disability, disability due to poverty, all of the above, none of the above. Lakshita is saying option number one. Nikunj is saying none of the above. Shubham is saying none of the above, but the correct answer is option number four, all of the above. All the disabilities are included under section 6 of the Limitation Act. Can someone open the Bear Act and read? Can someone not? Everyone can read the section again. I am also opening my Bear Act and reading the section again. I know you guys are confused with the words minor, insane, or idiot. Let me open my Bear Act and see the correct thing. It includes the physical disability, that's for sure. Because of poverty only. See, this was not a question that under section 6. The question was under the Limitation Act. Obviously, section 13 is there, right? Yes. So it is option number 4, all of the above. Not under the limitation. Why option number 5? All of you are answering none of the above. Permanent physical disability or disability due to poverty. Somebody is permanently minor, permanently insane, sorry, not permanently minor. Somebody is permanently insane. Yes, so the correct answer is all of the above. Okay, under the Limitation Act, the period of limitation for any suit or application shall be deemed to be extended for a maximum period of dash from the death of the person affected by disability. Acha, insanity is not a physical disability, it is a mental disability. ये बोलने की कोशिश कर रहे हो. Don't get confused, शुभम. इतना मतलब do not get into so much technicalities. It is a kind of disability only, which is included under section under the Limitation Act. Under Limitation Act, the period of limitation for any suit or application shall be deemed to be extended for a maximum period of dash from the death of the person affected by disability. 1 year, 2 years, 5 years, 12 years, or 3 years. Yes, it is 3 years. So this is also done. Do I think do you guys have any doubts under for the for the previous question? If yes, please mention the doubts in the chat box. Insanity is a kind of disability. It is both, like, this is not physical cruelty or mental cruelty. This is not do not relate it to that. So partial disability is also included, but it has to, like, if it is serious or not, that doesn't matter. Partial disability is also included. Disability due to poverty is included. Yes, I still have a doubt. Please ask Kritika. Please write it on the comment box. Under certain circumstances, period of limitation may be relaxed. Which of the following is not such a circumstance? If the court remains closed on the expiry date or last date for any suit or appeal, if the court suffered from legal disability except in cases of enforcing right of preemption, if the court is satisfied that there were sufficient reasons for the delay, if the delay is caused because the applicant was busy with the personal problems, none of the above. Option number D, option number 4 is with the personal problems. Option is all of the above. The answer is all of the above. All of the above are included under the Limitation Act. The question was under the Limitation Act. Whole act was asked, not under section 6. Yes, it is option number four. Due to personal problems, if the delay is caused, that is not an excuse. Section 7 of the Indian Limitation Act applies to in case of a delivery of possession of an immovable property, a case of delivery of possession of a movable property, both of the above, either one or two, none of the above. Section 7 of the Limitation Act. None of the above. It applies to certain kinds of property. Lakshata is saying both of the above, and the correct answer is option number one. It only applies to immovable property. Explanation one is the correct explanation, which you can refer to section 7. Yes, Medha was right before. Now she changed the answers. Changed the answer. Yes, Divya is right. Pritika is right. Only to the immovable property. Section 7 of the Limitation Act applies to only suits, appeal, or application, either one or two, both one and two. Section 7. See, management of the joint family property. Yes. It does not mean it also excludes movable property. You guys are saying this. Okay, the correct answer is both option number 5. Everyone is right here. Pritika was right. Divya was right. Shubham was right. It applies to both 1 and 2, suit and application. Huh. What about the last question? You guys are saying it does not exclude, it is not mentioned that it does not exclude the movable property. But if you'll read the whole section, the meaning of it is showing that, let me read the Bare Act again. Yes, it can be both movable and the immovable property. It says the section applies to discharge from every kind of liability, including a liability in respect of any immovable property, any kind of liability. Yes, so the correct answer should be both immovable and movable. It can be either one or two. Every kind of liability, yes, it includes movable and immovable. Yes. Okay. Section 7 of the Limitation Act means to free from liability. To free from liability. Okay. This is the answer was mentioned. Let's move ahead with the case law. Section 7 would apply when the right to sue in joint, irrespective of whether the substantive right is joint or not. This was held in Usha Banerjee versus Premier Insurance Company Limited, Ram Kali Koer versus Indra Deo Chaturvedi, Chaudhary, Sardar Prasad versus Lala Jamuna Prasad, Aryakandi Kunni Kannan versus Kotia Pazail Devaki and others, Jigyasa Devi versus Radhika Rani. Everyone is saying option number one. Acha, for the previous question, please answer the question for the correct case law, guys, or answer it as pass and mention the case law in your Bear Act. Yes, it is option number A, which is Usha Banerjee versus Premier Insurance Company Limited. Please mention this in front of section 7 of your Bear Act. Usha Banerjee. Yes, yes. Special exceptions. Nothing in section 6 or in section 7 applies to suits to enforce rights of preemption or shall be deemed to extend for dash from the cessation of the disability or death of the person affected thereby the period of limitation of any suit or application more than 2 years, 1 years, 4 years, 3 years, 5 years. Yes, it is option number 4, more than 3 years. It was directly taken from section number 8, which is special exceptions. Yes, continuous running of time, where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it, provided that the letters of administration to the estate of a creditor have been granted to his debtor. The running of the period of limitation for a suit to recover debt shall be suspended while the administration continues. The running of the period of limitation for appeal to recover the debt shall be suspended while the administration continues. The running of the period of limitation for an application to recover the debt shall be suspended while the administration continues. The running of the period of limitation for an application to recover the debt shall be continued while the administration continues. Yes, it is directly taken from the Bear Act itself, and the correct section is section number 9, if I'm not wrong. Yes, correct answer is option number 1. Pritika was right, Medha was right. It is mentioned under section 9. No rule of limitation in force in state of Jammu and Kashmir or in a foreign country shall be a defense to a suit instituted in the said territories on a contract entered into in that state or in a foreign country unless the rule was has extinguished the contract, the parties were domiciled in that state or in the foreign country during the period prescribed by such rule. Both of the above, none of the above. Yes, it is both of the above and it is mentioned under section 11. Correct. Everyone is correct. The law of the limitation finds its roots in which of the following maxim intrust republica ut sit fins litium vigilantibus non dormentibus jura subventium. Both of the above, either one or two, none of the above. Yes. Okay, everyone is saying one. Yes, everyone is saying C. Pritika is saying C. Divya is saying C. Medha is saying C. Yes, it is C. The first maxim means that in the interest of the state as a whole, there should be a limit to litigation, and the second maxim means the law will assist only those who are vigilant enough with their rights and not those who sleep on it. Yes. The Limitation Act came into force after repeal of which of the following act? Limitation Act of 1871, of 1877, of 1908, of 1874, of or of 1950. Okay, 1908, Pritika is saying, Medha is saying 1908, and it is 1908. By the Third Law Commission, the Limitation Act came into force after the repeal of Limitation Act 1908, which act is also of 1908. Which subject is also of 1908? Please mention on the comment box. As defined in Section 2L of the Limitation Act, suit includes appeal, application, both 1 and 2, either 1 and 2, either 1 or 2, neither 1 and 2. Yes, CPC, correct. 2L of the Limitation Act, suit includes. Okay, everyone is saying none of the above. Lakshada Medha is saying none of the above. It is none of the above. It does not include, it neither includes suit or nor application or nor the word suits neither include appeal nor application. Yes. Under Limitation Act, the applicant includes a petitioner, any person from or through whom an applicant derives his right to apply, any person whose estate is represented by the applicant, an executor, administrator, or other representative, All of the above, none of the above. Applicant. Yes, it is all of the above. Section 2, Clause A defines applicant. What is the period of limitation in the Limitation Act 1963 for suits relating to accounts? 2 years, 3 years, 4 years, 5 years, 6 years. Suits relating to accounts. Some quick questions from the schedule. ये आता है तो आता है, नहीं आता है तो नहीं आता है, नहीं आता है तो please do not apply in the exam. Abhi you can give your guesses. Pritika is saying 2, Shubham is saying 4. The only way to learn the schedule is dividing the parts of the schedule as it is divided and revise it again and again. Okay, 2, 4, 2. It is 2, it is 3 years. Suits relating to contracts, and which it is mentioned suits relating to accounts. The time period is 3 years. Yes. Limitation for claiming compensation for defamation is 3 years from the date when the libel is published, 3 years from the date when the published libel comes to the knowledge of the plaintiff, 1 year from the date when the libel is published, 1 year from the date when the published libel comes to the knowledge of the plaintiff, or from the date when the damage for which compensation is claimed is caused, whichever is earlier, whichever is later, 2 year from the date when the libel is published. Defamation. Okay. Pritika is saying 2, Divya is saying 3. Let's see. It is 3. 1 year from the date when the libel is published. Guys, can somebody tell me what is the limitation period? I asked this question, I think, in one of my IPC quizzes. What is the limitation for criminal defamation? Criminal defamation के लिए what is the limitation period? Mat Kholna Bear Act. Do not see the punishment of defamation under IPC. And then tell me the answer. Pass? Acha. Okay, the correct answer is 1 year from the date when the libel is published. So it is 1 year in the case of civil cases, civil defamation. Yes, it is 3 years. It is 3 years. Correct. The period of limitation for filing a suit for defamation for damages for defamation is 1 year, 2 years, 3 years, either one or two, none of the above. In case of criminal, it is 3 years. Correct, Pritika? Abhi hua your question. Yes, it is one. Article 75 and 76 are the relevant act for libel and slander. वही दोनों के लिए 1 year है. Of Schedule 1 of CPC, of Limitation Act. If no period of limitation is provided in the Limitation Act, the proceedings can be instituted within 1 year, 3 years, 12 years, or 2 months. 12 years and 2 months, 2 years, none of these. Guys, come on. Please, you need to answer this question and tell me the relevant article also. ये आता ही आता है. ये आएगा ही आएगा. If there is a question from schedule, this is the most important question. Yes, 3 years, and the relevant article is Article 113. Correct. Suits for arrears of maintenance can be filed within 1 year, 2 years, 5 years, 4 years, or 3 years. Suit for arrears of maintenance. Correct. Everyone was correct. Pritika, Divya, Medha, Shubham, Lakshita, everyone was correct. Suits for arrears of maintenance. Last few questions are there. कुछ ही questions बचे हैं. 3 years कोई बोल रहा है 1 year. The correct answer is 3 year. Article 105 is the correct article here. Suits for claiming arrears of maintenance can be filed within 3 years. In which of the following cases the reference on the question whether use of expression date in Article 54 of the schedule to the Act suggestive of a specific date in the calendar has been answered by the Supreme Court in Ramzan versus Hosseini, Tarlok Singh versus Vijay Kumar Sabharwal, Ahmad Sahab Abdul Mullah versus Bibi Jan, S. Bharmanand versus K.R. Muthu Gopal. Pass आ गया होगा अभी तक. Yes, both 1 and 2. Pritika writes very fast. Pass. Pass. Khatam. नो आइडिया, पास। वहां पे पास ही करके आना, वहां पे प्लीज डू नॉट मार्क सच क्वेश्चंस जो नहीं आते हो। Everyone pass. Might be two. Pratika is saying might be two. Okay, the correct answer is option number one, and it was a question in MP Higher Judicial Service, Ramzan versus Hussaini, and Article 54 is about, I think, the specific performance of a contract. For enforcing specific performance of a contract, and it is 3 years for specific performance of a contract. केस का नाम बड़ा लंबा है। ठीक है, अहमद साहब अब्दुल मुल्ला वर्सेस बीबी जान, पर वो नहीं है करेक्ट आंसर। करेक्ट आंसर इज रमजान वर्सेस हुसैनी। प्लीज मार्क इट इन फ्रंट ऑफ आर्टिकल 54 ऑफ योर schedule of the limitation act. Period for limitation, Ramzan versus Hussaini. Okay. Period of limitation for possession of immovable property or any interest therein based on title is 20 years, 30 years, 7 years, 3 years, 12 years. Everyone is saying 4 year. Everyone is saying option number four. That means 3 years, and it is option number five. That is 12 years. Article 65 is the correct article here. C. Possession of immovable property or any interest is always 12 years. Yes. Divya, please. Divya is correct. Pratika, please revise the schedule. Especially ये बड़े बड़े साल वाले तो 12, 30 ऐसे वाले तो 3 years वाले फिर भी they rarely ask. कुछ कुछ डेफर्मेशन या कुछ कुछ 1 year डेफर्मेशन, कुछ कुछ दे आस्क सम टाइम। 12 years वाले तो प्लीज लर्न इट बाय हार्ट। Limitation to file suit for possession of immovable property is 1 year, 3 years, 12 years, 30 years. It is option number three, 12 years. The question was repeated. Article 65 is the correct article here. By a landlord to recover possession from the tenant, the period of limitation is 1 year, 2 years, 3 years, 12 years, or 7 years. Recover possession from a tenant. Nobody is answering. The correct answer is option number four. It is 12 years. By a landlord to recover. Acha, tell me one thing. If there is a. Yes, it is 12 years. If there is a conflict between this limitation act and the state rent act, suppose Delhi Rent Act or maybe MP Accommodation Control Act, which law will prevail? Indian Limitation Act or the state local act? Possession may be filed within 6 months, 3 years, 2 years, 1 year, 12 years. Correct. Shubham is right. Possession may be filed within 6 months, 3 years, 2 years, 1 year, 12 years. State local acts, right. Local acts, correct, Medha. Possession may be filed within. Yaha card, you are not answering. You are answering the conceptual based question. I'm really proud of you guys. You are conceptually very strong, but रटने की power zero. You guys have not are not able to answer any question relating to schedule. Please उस schedule को याद करो. There's no other way doing it. I was also very bad at it, but I made it somehow. कुछ कुछ चीजें मुझे अभी भी याद है. Okay, 12 years. Yes, it is 12 years. Known as possessory title. So always, please, हमेशा 12 years वाले जितने भी हैं उसको अच्छे से याद करके आना जाना एग्जाम में. Then only you will be able to answer the questions relating to schedule. In case a suit in case of a suit by a person excluded from a joint family property, to enforce a right to share therein, the time from which the period of limitation, 12 years under Article 110 of the Schedule of the Limitation Act, begins to run is from the date of exclusion, when the exclusion becomes known to the plaintiff, when the plaintiff makes known his intention to recover possession, the date of refusal to hand over possession to the plaintiff, none of the above. Okay, when exclusion becomes known to the plaintiff, yes, it is under Article 110. When the exclusion becomes known to the plaintiff, then the time begins to run. Okay, so this was the last question, guys. How was the quiz? We are down with so many questions. My eyes have also started paining. I can understand your situation. You might have revised limitation and then came here. Please revise the schedule again, divide it into parts, try to learn by heart. The case laws I have mentioned, please mark the case laws on your Bear Act. How was the session otherwise? Fruitful one. Thank you, ma'am, for this great session. You're welcome. We discussed some controversial questions also, which you had it out, which I had it out, but we discussed it somehow and came to a conclusion. I think you have no doubt now. Lakshita's internet is, I think, slow. We are on the slide of thank you, all the best, and she's still answering the question. How was the session, Lakshita? How are you feeling? Are you feeling that you have revised the schedule well? But never, I have faced this. कभी भी एग्जाम के पहले कोई सॉन्ग एंड स्पेशली सच एडिक्टिव रील्स दीज डेज, ये मोए मोए वाली रील, दिस इज दिस इज लाइक स्टक इन योर माइंड. ये इतना एडिक्टिव सॉन्ग है, एडिक्टिव रील है, यू कैन से. तो एग्जाम से पहले दो चीजें बिल्कुल नहीं करना. डू नॉट बाइट योर नेल्स एंड डू नॉट रिसाइट अ सॉन्ग. नेवर. लक्षिता इज स्टिल पास. ओके, ठीक है. आई थिंक वो शेड्यूल वाले आंसर में अभी कोई प्रॉब्लम नहीं है. चलो, let's see you guys day after tomorrow. I think I'll be taking commercial codes act. Tomorrow is POXO, I think. थोड़ा बहुत तो होगा, दिव्या. But try not to mark such questions because Delhi has a negative marking. Those students who are preparing for MP, you can mark it. आप जाओ, there is no negative marking. By the way, MP में कुछ additions हैं syllabus में. Those of you who do not know, please check the syllabus again. And I'll meet you day after tomorrow with the commercial act quiz. Okay? Chalo. Bye bye.